toute personne accusée a le droit d'être défendue. C'est un droit inscrit dans notre loi suprême, la Constitution. Mais ce droit doit être réel, tangible. Avec cette loi d'actualité, ce gouvernement s'engage à rendre le droit d'être défendu accessible à tous, même pendant une enquête policière ou une demande de caution. Les mineurs entre 14 et 18 ans recevront automatiquement de l'aide, même sans devoir passer par leurs parents. Pour la continuité, Monsieur le Vice-président, ce projet de loi donne au chef juge les moyens de créer des règles adaptées pour bien faire fonctionner le système, les règles existant sous la loi de 1973 ayant été révisées il y a 5 ans de cela. Et ceci dans un souci d'encourager les hommes de loi, attorneys barristers, à s'engager à offrir leurs services in forma pauperis. J'ai pris note à Rodrigue que les professionnels qui se déplacent pour offrir des services in forma pauperis jouent un rôle essentiel dans la garantie de l'accès à la justice pour les plus démunis. Il est donc crucial de prévoir des solutions logistiques adaptées, l'hébergement adéquat afin de soutenir l'engagement de ces hommes de loi sur le terrain. Et les policiers, les magistrats, les juges et les hommes de loi devront informer les potentiels bénéficiaires dans une langue qu'elles comprennent. Et bien évidemment, à Rodrigue, c'est créole. À Rodrigue, beaucoup de gens ne savent pas encore qu'ils ont droit à cette aide juridique ou ils n'osent pas demander l'aide juridique. Ce projet de loi vient répondre à cette réalité, Monsieur le Vice-président. Cette aide légale va couvrir non seulement les affaires civiles comme les problèmes familiaux, les litiges de terrain, mais aussi des affaires pénales, les affaires de la police, comme on le dit souvent dans le jargon. Monsieur le Vice-président, ce gouvernement veut alléger les charges financières de nos concitoyens en supprimant certains frais de justice, ce qui va vraiment soulager les familles modestes. Ce projet est là pour aider un conjoint délaissé qui veut se défaire d'une union civile qui ne fonctionne pas et qui ne fonctionnera jamais. Un père ou une mère démunie qui veut avoir accès à son enfant. Un jeune accusé à tort, entre autres, qui mérite un avenir prospère. Il pourra avoir de l'assistance légale pendant l'enquête judiciaire, ainsi que de l'aide légale pour être libéré sous caution. Mais pour que tout cela fonctionne, Monsieur le Vice-président, chacun doit faire sa part. Nous avons tous notre rôle à jouer. J'apprécie que les professionnels du droit, les officiers de justice, les magistrats, les policiers auront un rôle crucial. Qu'ils soient et restent les gardiens de l'équité, qu'ils soient flexibles, justes et humains. Monsieur le Vice-président, les citoyens doivent aussi savoir que l'aide juridique est non seulement un droit, mais aussi une responsabilité. Il faut coopérer, faire une application, être honnête et respecter les procédures. Cette réforme était non seulement nécessaire, mais urgente. Connaître le véritable bien de la communauté, c'est ce qui constitue la science de la législation. L'art consiste à trouver les moyens de le réaliser. Je crois en cette philosophie de Jérémy Bentham, Monsieur le Vice-président. Comme Bentham, que je viens de citer, je pense que cette loi doit servir le bien commun. Et ce projet de loi-ci va dans ce sens. Avec ce texte de loi, nous rendons la justice plus proche, plus accessible et plus juste. J'invite donc mes collègues à soutenir ce projet avec responsabilité et engagement. Ensemble, construisons une justice qui sert tout le monde. Sur ce, je soumets ce projet de loi à l'examen de cette Assemblée. Merci beaucoup.
Bravo. Merci. Honorable Prayag.
Honorable Mr. Deputy Speaker, sir, distinguished members of the House, I wish to thank you for giving me the privilege to address this august assembly on this important legislation, that is the Legal Aid and Legal Assistance Bill. As a doctor who has witnessed the human consequences of delayed or denied justice, I rise to address the proposed repeal and replacement of the Legal Aid and Legal Assistance Act. At a time that lies at an intersection of human rights, fairness, and dignity, as rightly pointed by the Honorable Attorney General. Please allow me to be clear, Mr. Deputy Speaker, sir. Today, legal aid is not an easily accessible privilege, and it has not been one for the last decade. Due to the devaluation of our rupee together with the previous eligibility criteria, many of those who didn't know on which door to knock when they suddenly had to face legal charges and get legal counsel overnight. The new threshold of not exceeding 25,000 rupees and defined assets value not exceeding 1 million rupees make legal aid accessible again to the needy, and I congratulate the Honorable Prime Minister, the Deputy Prime Minister, and the Attorney General for this endeavor. The old law had made almost all relevant provisions, but in practice, it was not applied as it should. The new law should make provisions so as it does not remain an academic legislation without any real impacts on access to justice. This new reenacted bill has an objective to make it more accessible for persons with low income and who cannot afford legal representation to have access to justice in civil and criminal proceedings before any court in Mauritius. This legislation will ensure that justice does not remain the domain of the wealthy, but becomes a lived reality for all Mauritians, regardless of income. I am not a barrister, and I humbly stand to be corrected by fellow learned members of the legal profession. Yet the truth is, our current system pertaining to legal aid and legal assistance is falling behind. Let us agree that one of the key issues today is the bureaucratic and outdated process. Les dossiers traînent, les retards accumulent et la frustration s'installe. Ces délais découragent beaucoup de personnes d'exercer leurs droits à l'aide juridique. Quelquefois, les gens se perdent littéralement dans le système à cause de cette lourdeur bureaucratique. Monsieur le Vice-président, time is justice, delay is denial. Whilst reflecting about the process, I also feel the necessity to highlight the need for digitalization and streamlining of the legal aid application process. Let us not be the architects of that old system where divorce through private counsel today takes 2 to 3 months, while through legal aid it drags for a year. I somehow now feel that Clause 6 of this new bill, more specifically Clause 6.2b, must be clearly defined by a prescribed time limit so as not to delay justice. In addition, for such a legislation to work, I find it essential that police officers, especially those of senior rank, be empowered and trained to conduct real-time means testing and merits testing, particularly during weekends or after hours when courts are closed. We cannot allow someone to be detained overnight simply because no one was present to assess his or her eligibility. As a comparison, I wish to refer the House to the current UK procedure, where a duty solicitor is on call, readily available to represent an accused at any time of day or night, subject to eligibility. Unfortunately, under the draft before, the burden was being placed on the accused to prove their eligibility via an affidavit sworn before a district court. But what if someone is arrested at 8 p.m. on a Saturday night? The court is closed at that time and affidavit cannot be sworn. Then what happens? Does this mean the person remains in detention without a voice? Mr. Deputy Speaker, sir, this is neither fair nor just. If we are reforming this law, we must build clarity, accessibility, and fairness into its procedures. As we are aware, it is already the practice in Mauritius for a superintendent or assistant Superintendent of Police to remain on duty after office hours in every police divisions across the island. I shall propose that this designated officer is given proper training in legal aid screening and be empowered to receive a sworn statement of truth on eligibility. In the past, in Mauritius, I can recall that a superintendent of police had the legal power to grant bail. I hereby wish to mention that that is both reasonable and practical that such officers be entrusted with initial decisions on legal assistance as well. This measure would immediately bring fairness into the room. It is hereby time to see the practicalities of such a legislation. This new legislation will work, Mr. Deputy Speaker, sir. The previous act did not impose an obligation on the statement recording police officer to inform the person that he may make an application for legal assistance during the recording of the statement. However, I still personally don't find it sufficient. We need to correct the mischief of the law enforcing officer to escape the imposition of such an obligation of him or her. This same mischief, which the Honorable Attorney General will agree with me, the safe mischief that has unfortunately been played for years and years. It is to my opinion that the information of access to legal aid must be imperatively added as part of the official police caution. To make my point, Mr. Deputy Speaker, sir, I need to say that the right to legal representation is not merely theoretical. It must be stated clearly and immediately upon arrest. This is the norm in some jurisdictions, for example, the United States of America. It goes without saying that police abuse will decrease by imposing on the law enforcing officers to inform the accused of the right to legal aid upon caution. Mr. Deputy Speaker, sir, when police officers know that detainees are aware of their rights, they tend to be more diligent in their delivering of their duties, and especially when those rights are actually exercisable. We must also take practical steps to ensure public awareness. I propose that clear notices on legal aid rights be affixed in all police stations, in all courthouses, even in all citizen advice bureaus, and that also in English, French, as well as Creole. Many Mauritians still do not know what they are entitled to. This simple, visible step can change lives. Another significant point is that prompt payment to attorneys and counsels is vital if we expect them to take up sensitive cases, including those of rape, drugs, assault, eviction, often on short notice. We must honor them with timely payment. Otherwise, participation in the system will dwindle and we will be left with an empty shell of law. To me, this is a clear way to increasing the true value of the service, and I believe it is a matter that mandates urgent action. As the law is being repealed and replaced, the new act should clearly list the types of cases eligible. I have been informed that in practice, legal aid currently covers property-related matters, evictions, family law matters, and criminal cases as well as appellant cases across the various courts in our jurisdiction. But this should not be left to guesswork. Clarity brings confidence. That is why I would request your permission and take a moment here to brush a picture of victims of medical negligence. As founder, president of the Medical Protection Society of Mauritius, I have witnessed cases where patients suffer in silence, lacking both voice and recourse. Yes, in addition to extending legal aid to more women by, for example, partage, post-divorce, and licitation, we have had debates on this matter these few weeks. Legal aid must recognize and respond to the needs of those who have suffered due to medical malpractice and negligence. This is a category of litigation that is growing. We cannot leave these victims behind. Medical negligence cases are often complex, emotionally charged, and financially crippling. The very individuals who suffer from misdiagnosis, surgical errors, or systemic failures in our healthcare institutions are the least likely to afford quality legal representation. Are we, as lawmakers, prepared to tell them that justice is a privilege that they cannot afford? Take, for instance, the case of a young mother from a modest background who lost her newborn due to a delayed emergency cesarean section, an avoidable tragedy later confirmed by a medical review. Devastated, she was determined to seek accountability, but without the means to hire a lawyer, she was left without being able to afford a legal recourse. My personal assessment is that such legislation, if properly applied, can bring more confidence to the person approaching the court. The delay of 2 years to pursue government institutions according to the Public Officers Act makes it difficult for low-income earners to find money during this period of time, hence making it impossible to seek justice and repair. As a doctor, I can assure the House that such measures will bring more diligence in the noble work of medical and paramedical personnel and ultimately better care in our healthcare institutions. On ne peut plus accepter de continuer à voir les victimes dépourvues ou laissées pour compte. J'ai témoigné à maintes occasions des victimes finissant par accepter toutes sortes de remèdes à la fin. Before drawing my conclusion, I wish to state that if this Legal Aid and Legal Assistance Act were to be embedded under a main overarching framework, such as the model of the Police and Criminal Evidence Act in the United Kingdom, as announced on several occasions by the Honorable Prime Minister, it would carry more structural authority and legal weight. Housing this legislation under a primary act that governs procedural fairness and rights during arrest and investigation would ensure greater coherence, consistency, and enforceability across all related processes. It would also reflect our seriousness in placing access to justice at the core of our criminal justice system. In conclusion, Mr. Deputy Speaker, sir, let us be clear-eyed. This is not just a legal document we are debating. It is a gateway to justice for the voiceless. We must ensure that access to justice is practical, prompt, and protective. This new Legal Aid and Legal Assistance Act must be bold enough to correct the mischiefs of the past, compassionate enough to understand the realities of the present, and wise enough to future-proof the rights of generations to come. Justice delayed is justice denied, but justice denied because of poverty is injustice institutionalized. Let us all not allow that to happen. In conclusion, Mr. Deputy Speaker, sir, I must commend this bill to the House. Thank you.
Thank you. Honorable Lobine.
Thank you, Mr. Deputy Speaker. Let me first of all, Mr. Deputy Speaker, thank the Honourable Attorney General for bringing this bill to the House. It is clear that careful thinking has gone into the drafting of this legislation, and I also thank the officers of the State Law Office for this very clear drafting with regards to this particular piece of legislation. The Honourable Attorney General spoke earlier on about consolidating the welfare state. This is one aspect as how this government is consolidating the welfare state, Mr. Deputy Speaker. And unfortunately, when we are debating such an important bill, again, the other side, only 3 members, all of them are absent. It is a very important piece of legislation. At least they are not participating, at least they should be here, present, to show compassion as to the consolidation of the welfare state, because we are talking about accessibility to justice to the most vulnerable people of our society. So again, history will judge those members of the opposition who are always absent and who are always not here to participate in debates with regard to this important piece of legislation, Mr. Deputy Speaker. Why legal aid matters, Mr. Deputy Speaker? It goes beyond words, because it goes to the very foundation of our Constitution. Section 10 of our Constitution is the foundation that guarantees that one should not be denied access to justice because of lack of means. and that every accused person must receive a fair trial, including the right to legal representation when necessary to secure justice. This principle, Mr. Deputy Speaker, is at the heart of our legal aid framework. It ensures that access to justice is not just a privilege for the wealthy, but a constitutional right for all Mauritians. And here, I would take the words of Honorable Colette when she rightly pointed out that we are bringing a new law after more than 50 years. The previous Legal Aid Act was in 1973. It was brought by the then Labour government, establishing and consolidating the welfare state. And it was amended again in 2012 under a Labour government, again to consolidate the welfare state. And this was done again, Mr. Deputy Speaker, after a study, after a report of Lord Mackay of Clashford. Again in 1998, the then Labour-led government, we had a report from Lord Mackay, access to justice, reform to the justice system, and legal aid reform. And those reforms were already mentioned. And it is as per those recommendations that in 2012, amendment was brought, and the amendment expanded the scope from legal aid alone to include legal assistance. This was done in 2012, covering advice and support earlier in the process, like police inquiries and bail. This was a step forward for access to justice, especially for juveniles. But beyond that single reform, the system remained largely frozen. Thresholds stayed outdated. There was no clear statutory duty to inform people of their rights. And here, as rightly pointed out by Honorable Dr. Prayag, there should be more clarity. But this particular piece of legislation, in this bill, clarity is provided, Mr. Deputy Speaker, with regard to Clause 4, the right to legal aid. Now, it is an obligation on our Court of Justice to ensure, to tell anyone who is being accused or standing trial that before the start of the proceeding to which that person is about, to inform him in a language in which he is conversant that he may make an application for legal aid under this act. This is now in the law. And it goes further. It goes further. Again, the right to legal assistance, Mr. Deputy Speaker, at Clause 10 again. It is also a duty of the police officer in charge of the police station that he may make an application. He shall inform that person that he may make an application for legal assistance during police inquiry, including legal advice. So this is also now being enacted. It will become a law. However, as pointed out by Honorable Dr. Prayag, in practice, how will it work? How do we communicate? What is the time frame that will be set up to look at all these applications? What about the status of the number of personnel that will be allocated in different courts of justice to process those applications? Whether those people who do not know the law or who are not able to access information as to they are eligible for legal aid, whether they know that they are eligible to legal aid, who will go and inform these people? Here, Honorable Dr. Prayag has mentioned that we should, in the Court of Justice or even in public places, have clear billboards informing people. This is done in the UK, Mr. Deputy Speaker. Inform those people. Also give pamphlets at the courts of justice. It is done in the UK. What are your rights? What you can be doing? What you cannot do? So for legal aid as well, I think there should be a campaign of dissemination to inform the public at large what they can do, what they cannot do, and who are eligible. And with regard to, again, the report of Lord Mackay, the Mackay report, Mr. Deputy Speaker. The report spoke about the creation of an independent legal aid authority, creating an independent body responsible for administering legal aid, ensuring transparency, efficiency, and impartiality. So maybe when the Honourable Attorney General will sum up, he might give us some indication whether in the near future they would consider setting up a legal aid authority as recommended by Lord Mackay and as also being opined by the Law Reform Commission way back in 2011, whereby the Commission said, the current, I quote, it's an opinion paper of the Law Reform Commission in February 2011. I quote, the Commission is of the opinion that the current legal aid system is certainly in need of reform. Legal aid should include legal advice and should not be restricted to legal representation. And a legal aid board or commission should be established. Because in the current system, again, Mr. Deputy Speaker, I'm humbly voicing out my opinion because I've been speaking to various colleagues of the profession, and I salute the legal profession, hundreds of attorneys, hundreds of counsels, barristers who are working in the system of the legal aid, who are giving pro bono services, and I salute their efforts because most of those barristers, they are compassionate, most of those attorneys, they are compassionate, and they deliver against all public perception that they might have against the legal profession. Most of those cases, most barristers, they do not charge a single cent from government, from the legal aid unit. They do it pro bono, seriously and compassionately, and they take the case as if it is their own case as being paid by an independent person that will come and knock at the door. So I salute the legal profession. I salute all attorneys and barristers who are working within the system. But again, there are certain issues that I wish to raise with regard to separation of powers, Mr. Deputy Speaker. So again, we are giving unfettered powers to the Chief Justice to determine fees to be paid to barrister and attorney from the consolidated fund. Maybe is it not the right time for us? We are consolidating democracy. Whether is it not high time also to open the debates whether the legal profession should be independent, not just in the sense of the word, independent in the way we operate. The legal aid system should not be under the umbrella of the court and of the Chief Justice. There should be an independent legal aid authority, independent, impartial, that would look at all the procedures and put in place this very beautiful piece of legislation. So I would invite the Honourable Attorney General to consider same and also consider the time frame as being proposed by the Honourable Dr. Prayag at clause 6 of this bill, application for legal aid. There should be a certain time limit to process, because we know how it functions and we know the bureaucracy that it involves in those people looking where to go to search for legal aid and how their application are being processed. So these are my contribution as to the debates on this particular piece of legislation, which is a beautiful piece of legislation, which is also something that we should commend, especially these are the debates, no? So we can't have everything good in a piece of law. So the strength of this new bill is that it updates eligibility threshold. This is very important. It will touch the most vulnerable. It also gives the duty on courts and on the police officer to inform people. It is now mandatory. It is legal for them to inform people that they are eligible for legal aid. And of course, it is also something that is very important that is being introduced, preserving the automatic protection for juveniles. This aligns us, Mr. Deputy Speaker, with the obligations under the UN Convention on the Rights of the Child. So these are my contribution to this piece of legislation, and I shall certainly support this bill, and I invite the Honourable Attorney General to consider the suggestion, the humble suggestion that I'm making on behalf of the profession and also with regards to this issue of separation of powers. Thank you.
Yes, Honourable Mr. Subron.
Mr. Deputy Speaker, sir, it is with a sense of duty as a minister, as a member of the National Assembly, and as a spokesperson of Resistance et Alternative that I speak in support of the Legal Aid and Legal Assistance Bill presented by the Attorney General. Sitting next to him in this National Assembly, I know that this bill has been one of his priorities since he took his seat in this House. On several occasions, he has shared his views with me on what amount would constitute a reasonable criterion for entitlement to legal aid. Even just a few days ago, we were still exchanging views on this matter. Well, this afternoon, this bill is just minutes away from being adopted, and I would like to place on record my deep appreciation for the enlightened vision of the Attorney General in bringing forward this amendment. Now let me share my input on this debate. Let me begin with the fundamental question. What is justice? Justice, as we conceive it today, has evolved from long, often violent and unjust past. There was a time, Mr. Deputy Speaker, sir, when justice was designed, administered by the powerful for the powerful. There was a time when disputes were resolved through personal vengeance. A perceived wrong was met with a bullet or a rope, reminiscent of the era of cowboys, where shooting someone or hanging them in the town square was considered justice. This was the rule of the strongest. But society has since evolved. Modern justice has become institutional. It is the state and a genuine democracy that now assumes a responsibility for law and order. It is the state that ensures the application of justice through structured, independent legal systems. But even within this evolution, we must acknowledge a painful truth. We still live in a deeply class-based society. There are the rich, there are the poor. And in this unequal society, justice often comes with a cost, one that many cannot afford. This cost becomes a barrier to equality, a denial of justice. In fact, for a significant proportion of our population, especially those from disadvantaged socio-economic backgrounds, justice remains inaccessible. In a patriarchal society, where relations between men and women are often unequal, this denial of justice becomes more pronounced. There is hidden exploitation, abuse, violence. Many women find themselves at the mercy of these injustices, without the financial means or institutional support to defend themselves. In these circumstances, access to justice becomes not merely a procedural right, but a fundamental human right. Access to justice is not just a principle, it is enshrined in international law. Mauritius is a signatory of the International Covenant on Civil and Political Rights, ICCPR, which in Articles 14.1 and 14.3d recognize the right to legal aid, especially in criminal cases. The Covenant insists that no person should be denied the right to a fair trial due to lack of resources. The right to defend oneself in a court of law is a cornerstone of justice. When Article 14.3d of the ICCPR specifically guaranteed legal aid in criminal cases for those who lack the means to pay for legal representations, Article 14.1 establishes the broader principle that all persons are equal before the courts and tribunal. In essence, the right to justice cannot be the privilege of the wealthy. It is the right of every citizen. The Human Rights Committee has further clarified that legal aid should also be extended to civil and administrative cases, especially when fundamental rights are at stake. Victims of torture, victims of sexual violence, and children, these are the group for whom access to justice must be guaranteed. Mr. Deputy Speaker, sir, let us look at the broader picture. In a class-based society, access to justice is not distributed equally. Those with the means can afford the best lawyer. Some of them are found in this house. They know the system, they can navigate it. But what of the poor, the working people, the ordinary citizens? What of the vulnerable? Often, they do not even know their rights. They are intimidated by the complexity of the legal system. They lack literacy, legal literacy. They cannot afford legal representation, and they are left voiceless. Let us not mince our words. The justice system across the world, as it currently operates, is often biased in favor of the powerful. There are systemic biases. People are disadvantaged. Of the disadvantaged backgrounds face harsher penalties, less favorable outcomes, and delayed justice. This is not justice. This is a structural violence. Access to justice, Mr. Deputy Speaker, sir, means more often than just the ability to step into a courtroom. It means having the knowledge, the support, and the representation needed to assert one's rights. It means able to understand legal procedures. It means having the legal assistance to pursue a legal case. And it means not being excluded of poverty, language, or social status. If we fail to provide this, the consequences are dire. We reinforce inequality. We erode public trust in the legal system. We invite social unrest and instability. To address this, it is important that we support legal aid and pro bono services. We should work to increase legal literacy and consider reforms to the legal system itself. Investigating in alternative dispute resolution is also essential. Ultimately, we need to create a system that works for everyone, not only for those who can afford it. The Legal Aid and Legal Assistance Bill by the Attorney General must be situated in this broader context of full access to justice. This amendment to enlarge access to justice for our people forms part of a broader democratic process, change process underway under this government. Let us now turn to the specific context of Mauritius. Mauritius has a unique history, a history shaped by slavery, by indentured labor, by colonial denial of justice to the majority of those who toiled for this country. The right to justice were intrinsically linked to our social and political emancipation. With independence, we enshrined civil and political rights in our constitution. Though immense progress has been achieved since then, we are a society that remains unjust towards the lower classes and towards women. Legal assistance in practice has been costly. It has been reserved for an elite, though our constitution and law recognize the right of citizens to legal assistance. The threshold has long been set to a mere 10,000 rupees. This threshold has excluded many, and in practice, justice remained inaccessible for too many Mauritians. The Legal Aid and Legal Assistance Bill before us today aims to address these deep-rooted injustices. Its object is clear: to repeal the existing legislation and to introduce a modern framework that makes legal aid accessible to persons with low income who cannot afford legal representation. The bill does several important things which have been underlined by my colleagues. It increases the income threshold from 10,000 to 20,000 rupees on the methodology proposed and described by the Attorney General. It expands the list of offences for which legal aid is available. It imposes new obligation on courts and police officers to inform citizens of their right to legal aid in a language they understand. It addresses existing shortcomings and corrects long-standing anomalies. We must, for instance, under the new framework, if a woman applies for legal aid, her application will no longer be evaluated based on the family's total income. The husband income will no longer count against her. This is the major step towards injustice for women, particularly in cases of domestic violence and matrimonial disputes. We must emphasize this point. The overwhelming majority of legal aid applications today concern matrimonial matters. Women seeking divorce, custody, protection from abuse. These women need the support of the state, and the bill answers that need. Mr. Deputy Speaker, sir, let me give some, real-life scenarios, reality. What would have happened to someone from the lower ranks of society, poor without legal connection, if they were falsely accused, if they were victims of planting by the police under the previous regime? Let us remember my friend B.L. What would have happened to him without legal assistance, without being assisted by my colleague Shakeel Mohamed? Or what would happen to A.B.? Would he have survived the system if he had been poor and unable to defend himself? What about the woman who killed her abusive husband in self-defense of the years of domestic violence? If she had no access to legal representation, would she have had a fair trial? Would justice have been served? How many young men have been victims of police brutality because they had no means to hire a lawyer? How many has died in police custody? And let us not forget the many everyday cases, the nearby disputes, the inheritance issues, the workplace conflicts, where the poor are left defenseless against the wealthy simply because they cannot afford a lawyer. Let us look at the numbers. The stats from 2020 to 2023 shows the following. First, on average, during the past 4 years, during the 4 years in question, only 1/3 of those who applied for legal aid were granted assistance. Second, on average, 92% of the application are for matrimonial cases. Third, though criminal cases are of prime importance for many citizens, application for legal aid related to criminal case was a tiny proportion of legal aid applied for. For the 4 years, 2020 to 2023, the proportion was 1.06 of the application of legal aid. Fourth, the number of requests for legal aid assistance peaked in the year 2020 with 4,965 applications, while in 2023, the number of applications dropped to 1,532. From 2022 to 2023, the expenditure on legal aid increased by 66.6%, from 1.7 million to 2.7 million. This shows that the growing demand, despite the low threshold, the growing demand and the state growing recognition of the importance of this service. The need is immense, and the current system is not meeting it. Legal aid is not a luxury, it is not a charity, it is justice. It is one of the pillars of a sovereign and democratic state. Mr. Deputy Speaker, sir, the Legal Aid and Legal Assistance Bill is a step forward. It is a progressive measure, it is a necessary measure, it is a response to the cries of those who have waited too long, suffered too much, and been ignored too often. Let us remember the fundamental truth. Non-access to justice is justice denied. This bill gives voice to the voiceless. It brings hope to the hopeless. It tells every citizen, rich or poor, man or woman, that they are equal before the law. This is what justice looks like. And with these words, Mr. Deputy Speaker, sir, I commend this bill to the House. Thank you.
Thank you. Honorable Minister Mohamed.
Thank you, Mr. Deputy Speaker, sir. I was sharing with the Honorable Deputy Prime Minister a few minutes ago. The difficulty I find myself in is, after having listened to everyone on this very important piece of legislation and the excellent speech pronounced by the Honorable Minister of Social Security and the others, I find myself with very less, because I don't want to repeat whatever they've said. However, just to pick up from where my honorable friend, the Minister of Social Security, has left off. Everyone agrees that the whole idea of legal aid is indeed for the issue of access to justice to be resolved. I have had the opportunity of reading the past legislations back in the 70s, and I've had the pleasure of reading some of the excellent presentations made by those who are no longer with us. Honorable Olivry, for instance, Honorable Dugnaville in those days. And the interesting thing is that everything that my learned friends from the bar have said here, even including the Attorney General and honorable members have said today, is exactly what they were saying back in the 70s. In other words, it is a fundamental right, that of having access to justice, that one should not curtail the access to justice, one should not put barriers to that access, otherwise we would be defeating the purpose of access to justice. This is exactly what then Honorable Guy Olivry was saying in this House. And I find it, as I say it again, interesting that now we are in 2025 and we are saying the same thing. So somewhere, somehow, something has gone wrong. We have the habit in this republic of ours of having beautifully written laws. But we also have the bad habit of not being able to enforce laws. So when I read our Constitution, and our Constitution says at the very start, and some people from the previous government failed to understand what exactly Section 1 of the Constitution means. Mauritius shall be a sovereign democratic state. What is democracy? Democracy is just not having the right to say something, but democracy is wider than that. And part of democracy is also the element of access to justice. Because if you don't give proper access to justice, democracy is stifled. You're killing democracy. And when I go to Section 10 of the Constitution, it's even more interesting, because the framers of our Constitution, provisions to secure protection of law, subsection 2C, every person who is charged with a criminal offense shall be given adequate time and facilities for the preparation of his defense. But I don't stop there, and the Constitution doesn't stop there. It goes further, subsection D. And this is where the subject of this debate today takes all its relevance, because it finds its footing, its source, at section 10(2)D of the Constitution. It says, every person who is charged with a criminal offense shall be permitted to defend himself in person or at his own expense by a legal representative of his own choice. And I go further. Or where so prescribed by a legal representative provided at the public expense. So the whole idea of providing someone, a lawyer, to represent someone in a court of law at the public expense is there in our Constitution. And why do I stress on that, Mr. Deputy Speaker, sir? It's because here I speak to the nation. And what I see in front of me, as other friends have reminded us, 2 empty chairs. Three. Oh yes. I say 2 because sometimes some people do not know where they stand. And very often they try to sit on the fence. And I've always said, be careful when you sit on the fence, it will hurt physically. So we have those 3 empty spaces. But not only are the seats empty, and it is not the first time that the opposition chooses not to be present. They choose not to be present, but hear me out. They believe by their absence that they have nothing to contribute to this piece of legislation. And what is this legislation talking about? It talks about providing help. Let me simplify it. Those who can't afford justice, those who can't open the doors to a court of law, to have a lawyer next to their side, or a solicitor, an attorney, that we give them that possibility without any barriers. This is what the law is about. So it addresses those who can't afford. In other words, the poor, those at low income, those who need our help, those who need our attention, those who need us to listen to what they're saying. And this is an example of how this government is not only listening, but through what the Attorney General and this government has done, we've acted upon what we've heard. Not only listened, but we've acted upon what we've heard. And this is the result of the action, this piece of legislation. Opening the doors to the courts, to justice. And not only leaving in our Constitution the simple theory that what the Constitution says, you shall be able to obtain at the expense of the public, the state, a representative. But it doesn't leave it in our books. We turn it into reality. So today, when I see those empty seats, what it says to me is that they are not interested. They are only interested in going out there and telling people, well, this is what is being taken away from you. But they are not interested, or they do not realize, either out of incompetence or of sheer ignorance, choose it, left or right they lose. They are not even aware that this is such an important piece of legislation that we are here putting into practice what is in theory provided for in our Constitution. This is a shame, Mr. Deputy Speaker, sir. So and I want people out there, through those words, through my words, through the words of all our friends in this assembly who have chosen to be present, to look at what those empty seats mean. That for them, the people who want access to justice, they mean nothing to the opposition that should have been here but have chosen to be absent. Mr. Deputy Speaker, sir, I have had an interesting read of a document entitled "In Mauritius, Courts and Police Confront Weakened Public Trust Amid Persistent Perceptions of Corruption." This is Afrobarometer, which is of 6th of September 2024. The first page of that document, I quote from it, Mr. Deputy Speaker, sir. It says, Afrobarometer's latest survey in Mauritius sheds light on public perceptions of the judiciary and police. Findings show that a mere 1/5 of Mauritians view the rulings of judges and magistrates as completely free from political interference. And who was in power then? The empty seats. They've run away. 2/3 of citizens suspect that at least some judges and magistrates are involved in corruption. I'm not saying it's true, but this is the perception. A perception encouraged by a government whose representatives today in the opposition have chosen to run away. But it's encouraged by a government that did nothing for access to justice for 10 years whilst they were in power. And what the study also shows, and it's interesting, the reading of this study, it shows that people with low income are those who do not trust our justice system the most. That's interesting. People with low income are those that don't trust our justice system the most. In other words, when you do not open up the issue of accessibility to justice, when you do not come up with legislations of this nature, when you do not do such a marvelous job as the Honorable Attorney General has done, That is when you encourage those who do not have enough money to pay a lawyer or pay a solicitor. You encourage those people not to have confidence in the judiciary. And what I find interesting at page 11 of this report, which is dated 6th of September 2024, at page 11 of this report, I find it interesting. And I then rejoin what Honorable, what Honorable Lobine has stated. And it says here at page 11, more than 58% of Mauritians say they are not aware of any legal aid services in their community. This is serious. So what is the point of having beautiful laws if you do not know that this is what you have access to? So yes, I agree, and I'm sure that the Honorable Attorney General has taken note, and I'm sure that those who will be responsible for the manning of the system will take note of what has been said. We have to let them know that they have access to this. We have to let them know not only that they have access to this, we also have to let them know that not only we participated in the process of giving them access to it, but there are certain people who chose not to participate. That also they have to know. But I'm not saying that we have to put it on a flyer, that one. But then again, I mean, they have to know. So what I find of most interesting, and I'd like here to quote a judgment, that of A.S. Mahmoud versus the Queen, 1991, Mauritius Reports, page 223. In that judgment, it says, I quote, "The concept of fair trial, guaranteed by Section 10 of the Constitution," the section I just referred to, "implies fair and impartial inquiries into the allegations of accused parties, the more so when, as in the present case, the accused is detained pending his trial." In other words, you cannot have a fair trial without a fair inquiry. And how can you have a fair inquiry, subsequently a fair trial, if the person who is suspected of having committed an offense, I use that as an example, if he does not have access to legal advice and legal assistance at the time that he is being questioned as a suspect? How can he benefit from any fair trial if him is not taken care of from the very start? So that is why, Mr. Deputy Speaker, sir, it is always easy to read a piece of legislation. It is nice to be able to write it, but then again, to remove it from the Constitution, bring it into legislation, and to give it life, for it to mean something to people who need that assistance. This is the whole beauty of our system. And that is why it is a beautiful piece of legislation. That is why I congratulate the Honorable Attorney General and his officers and all those who have helped in the drafting of this piece of legislation. And this is how I hope we will continue admiring what the Honorable Attorney General... let me say this. I know for a fact, many of us are lawyers here. Every single person who are lawyers in this house, I must say, including myself, we don't wait. We have not waited for the legal aid system to function, for us to represent people pro bono, including yourself, Mr. Deputy Speaker. We do it. But I think it is important not only that we continue doing it. Let me say en passant that I miss the fact that I don't do it nowadays, but that we continue doing it. But I think that it's good now that we have a structured system that is clearly a better system. Those are my words. And I
Thank you, Honourable Minister. Honourable Attorney General.
I will certainly not start blowing my own trumpet by saying that it is a beautiful bill. I'm glad to see the support of the House to this bill, which, as I have said earlier, is one of the most important I have brought to this House today. One must understand how the legal aid application or system works. It is a decentralized system. That is, at the Supreme Court, you have a legal aid unit which is headed by the senior appointed judge, the number 2 of our justice system. Then at the intermediate court, the industrial court and district courts, the presiding magistrates of this court, of these courts are the ones who actually deal with applications. They see these applications day in, day out, and I think we should trust this decentralized system for the time being in order to see how this bill, this act will work in practice. There is no doubt that there will be a necessity to empower the legal aid units at all levels in order for them to be able to process these applications so that the system is not clogged by the number of applications which will inevitably go up. Let me reassure the House, the swift processing of applications will be a priority. The expeditious necessity for a quick decision, especially needed in criminal matters when a citizen needs advice whilst in detention, or if his interrogation might lead to his arrest. This answers the question of the Honourable Member of Rivière-du-Rempart regarding legal advice. This is covered, I must say, by the legal assistance proviso in clause 10.1 of the bill. So there will be a need to expedite matters and, of course, to empower the legal aid units in all the courtrooms. Now, I also agree that there is a need to have an overarching enactment in order to give more, how can I put it, more oomph to this legislation. The long-awaited police and criminal justice bill is not just a dream, as some might think. It is real. There is a draft ready, and it will be brought before this House within a few months, just like the National Crime Agency bill. These pieces of legislation are important to this government, and they will be brought before this House very soon. In the meantime, we shall continue to bring forward litigation that will clarify processes, rationalize them, and in so doing, increase access to justice. I take good note of the proposition to review the Public Officers Protection Act. Let me reassure the Honourable Member that I'm on the same wavelength as he is. From day one, it has been my aim, and I hope to be able to fulfill this goal, to actually shape the system so that every citizen of this land feels that he has or she has been taken care of, and that he or she has not been left behind because of lack of means. As the explanatory memorandum to the Act states, it is a modern legislation with a view to making it more accessible for persons with low income and who cannot afford legal representation to have access to justice in civil and criminal proceedings before any court. It imposes certain obligations on courts and police officers to inform citizens of their right, and, as you have all stated, it clearly also addresses shortcomings in the law with regard to legal aid and legal assistance. With these words, I commend this bill to the House.
Need to be seconded. Seconded by the Deputy Prime Minister. The question is that the Legal Aid and Legal Assistance Bill, number 13 of 2025, be read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
Committee stage.
Thank you. Can you remove your seat?
Clause 1, short title. Clause 2, interpretation. Clause 3, application of act. Clause 4, right to legal aid. Clause 5, eligibility for legal aid. Clause 6, application for legal aid. Clause 7, legal aid in criminal appeals. Clause 8, grant of legal aid. Clause 9, grant of legal aid to juvenile. Clause 10, right to legal assistance.
The question is that clauses 1 to 10 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 11, eligibility for legal assistance. Clause 12, application for legal assistance. Clause 13, grant of legal assistance. Clause 14, legal assistance to juvenile. Clause 15, assignment of barrister and attorney. Clause 16, cost. Clause 17, exemption from duties and fees. Clause 18, rules. Clause 19, regulations. Clause 20, repeal. Clause 21, traditional provision. Clause 22, commencement.
The question is that clauses 11 to 22 stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it.
Schedule.
The question is that the schedule stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it.
Title and enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. The question is that I do report to the House that the Legal Aid and Legal Assistance Bill number 13 of 2025 has passed the committee stage without amendment. Those in favor say aye. Aye. Those against say no. The ayes have it. Yes, resume your seat. Honorable members, I have to report to the House that the Legal Aid and Legal Assistance Bill, number 13 of 2025, has passed the committee stage without amendment.
Third reading.
Honorable Attorney General.
I move that the Legal Aid and Legal Assistance Bill number 13 of 2025 be read a third time and passed.
Seconded by the Minister of Housing. To then put the question. The question is that the Legal Aid and Legal Assistance Bill number 13 of 2025 be read the third time and passed. Those in favor say aye. Aye. Those against say no. The ayes have it. Honorable Prime Minister.
Mr. Deputy Speaker, move for the adjournment of the House to Tuesday, the 15th of July at 11:30.
The House stands adjourned.